Welcome to another edition of Legal Straight Talk. I'm Tom Mealy. I'm here with the Harrison Law Group, attorney Brett Harrison and Richard Coleman. And I just want to let you know before we start, if anybody out there would like to ask either one of the attorneys a question, Evie, can we get a number up on the screen? The number you see right on the screen right now, 631-669-7999. Our lines are open. Please feel free to give us a call. Last week, we started to touch on a couple of topics, and I think we left off with the issues of no fault and what is no fault. So what we're going to do is we're going to jump right back into the no fault issues, just kind of recap on what no fault means. There's so many people have a misconception of that word, and unless you truly understand it, it's not that you are entitled to something because you're not at fault. No fault has absolutely nothing to do with the liability issue. It has to do with your medicals. So right now I'm going to turn to Brett Harrison. And Brett, if you could just highlight just a little bit on and recap on the issues of no fault and what no fault is, I'm sure that would be appreciated.
Good morning, everybody. Hopefully everyone's safe. No fault really, I'm just going to expand a little bit of what you just said, Tom, which is basically when you're in an accident, right now we're not concerned with who caused the accident, why the accident occurred. It's just a matter of what car you're in. And now I'm only talking about no fault from the standpoint of two-car accident. The car that you're in is called the host vehicle. And regardless of fault, that's why it's no fault, it involves now paying for your out-of-pocket and your medical expenses. Medical expenses as well as whether it be hospital, as well as lost wages, as long as it's on the books, which we'll get to a little bit later. That's the key. And the other key here now is you have 30 days from the date of the accident to file a no-fault application. But more importantly, you generally, within the first 24 hours, I believe in most policies, is that right, Rich, that you have to pretty much contact your no-fault carrier, your insurance carrier, be it Geico, be it Allstate, or any of them.
I think the policies basically state within a reasonable period of time after the accident. So obviously you don't want to wait. You want to notify your insurance company as soon as possible after the accident.
Right. I mean, you could be in a hospital and they're not going to say, if you're in a hospital in a coma, you know, or you just can't get anywhere because you're so injured. But you want to show within a reasonable amount of time as quickly as possible. You also, at the same point, when you're in an accident, as we discussed last time, it's very, very important to make sure that you contact the police at the scene, have them come and take a report. It's also, usually it takes about 48 hours to 72 hours to probably get one of the police reports. But at the scene, you usually can get the accident number.
Brett, let me ask you a question. There's, I'm reading something here regarding no-fault law. Now, no fault doesn't necessarily apply to every aspect of an automobile accident. Motorcycles are not usually covered under no-fault benefits. Again, medical benefits. Is that correct?
Yes, that is true. However, if you're a passenger on a motorcycle, then there is medical coverage.
And certainly if you're a pedestrian and you're injured due to an accident with a motorcycle, the motorcycle insurance carrier would provide no-fault benefits to the pedestrian that's injured from the motorcycle.
Now that's interesting. Let's talk about if you're a pedestrian. Now, if I'm walking down the street and all of a sudden this bike comes flying out of the side street, hits me, and I wind up getting hurt, I am also entitled, if I own a vehicle, to go under my own no-fault benefits, which would be under my insurance company, correct?
Well, that's not primary. The first would be the car that hit you or struck you or you were involved with, whether the pedestrian walked into the car or the car hit you. Again, remember, no fault's not about who caused the accident.
But you can have an extended policy, and this is something that we're going to cap on later on as the series continues, on what is a good insurance policy, what is a fair insurance policy, and what is ridiculous. Having multiple hundreds of thousands and thousands of dollars worth of coverage. But again, that's a topic for another day. So what you're saying that is, if that motorcycle hit me, we're going to go under that no-fault insurance or so-called medical insurance of that motorcycle first. And if we exhaust that, then I have an option, should I have the policy, which would be an extended personal injury protection policy, I can then go after that and cap that. But if I'm not mistaken, is that refundable to the insurance company after the case? My part of it.
Well, there are most policies that are written in New York have what's called an anti-stacking provision. So, for example, if you exhaust the no-fault policy of the insurance company, in your example of the motorcycle that struck you, which is typically in New York a statutory minimum of $50,000, if you exhaust that, meaning your medical bills exceed and your other bills, doctor bills exceed $50,000, it's questionable whether you can stack on your automobile policy no-fault insurance company. What typically occurs is that once you exhaust the no-fault policy, say, of the motorcycle insurance company that struck you, if you have major medical insurance coverage from work, for example, that typically would be the next level of insurance coverage that you would have available to you once you exhausted the no-fault. And to answer your question, if you proceed that way, the major medical insurance company would claim a lien or subrogation claim for any benefits that they paid that you may receive against any monies you receive from the motor vehicle or the motorcycle accident.
Gotcha. All right. So, so again, and understand something. We're airing throughout the country and technically around the world. But the issues is, again, certain laws change in certain states that you're in. So if you're watching us out there in Colorado, again, we want to reiterate, if you have a question regarding personal injury law and you don't know who to go to out in Colorado, you give us a call, and the number you can contact the Harrison Law Group is very, very simple. It's 516-390-0808. I'll be mentioning that number again throughout the show. But you can give us a call and you can let us know, exactly what state you're in, and then we'll help you out accordingly. So let's talk about a couple of different things, Rich. I know that when we were talking before we went live, there is a multitude of different types of accidents, from slip and falls to automobile to constructions, et cetera, et cetera. Let's talk about a construction accident or something outside the realm of automobile. Let's talk about what we know as a construction type accident. What do they actually call that?
Well, there are different types of accidents that occur at a construction site. And if you're injured in that context, you may have a claim, you may have a case that you can bring. Let me go over a few of them. Let's say you're a pedestrian and you're walking by a construction site, and they have put some boards to allow you to walk around the area of the construction site. And one of those boards are not properly affixed or are defective, and you fall or are caused to be injured on that board. You may have a claim against certain companies that were involved in owning and maintaining the work site where you were injured. So that is one type of case in a general sense. The other type of case involves individuals that are actually working at the job site and get injured in the course of their employment. Now, if you recall, in one or two of the other shows, we may have discussed about workers' compensation. Basically, if you're injured in the course of your employment in New York State, you can't bring a case against your employer and sue that employer for negligence because of the bar of workers' compensation. Workers' compensation provides benefits to the working individual, basically medical benefits when they're injured in the course and scope of their employment, or indemnity or a partial loss of earnings. These are lifetime benefits.
Let's talk about a labor law case, Rich.
Okay.
Which now spans outside, the comp and the regular type of construction accident. Now let's talk, because there's a lot of construction workers.
Oh, yeah, a lot of
throughout the
construction
country.
workers. The construction industry statistically is the second most dangerous industry and occupation in the United States. Believe it or not, farming comes first. So as you can imagine, in large construction sites or even smaller construction sites, there are a lot of dangers on the job. If you're working for a subcontractor and something happens to you where you're injured, and there are many different ways to get injured, you may have a case or a claim that, as you know, you can't bring against your employer, but you may have a claim against the owner of the job site or the general contractor on the job site, and or perhaps another subcontractor that was responsible for overseeing, maintaining, owning the particular area and the instrumentality, as we say, that may have caused the accident.
Now, Rich, there are certain exceptions where, even in workers' comp cases, and labor law cases, where you may be able to go to after your employer, and that's very important as to why you need to, after you're injured and you're trying to, as a layperson, try to figure out what went wrong. It's very important to go to an attorney, because time is very important, because a lot of times evidence disappears, preservation of tapes. In a lot of sites, they tape things. There may be different violations that maybe the employer knew about and disregarded. And so that's why it's also very important. And also, even from a no-fault standpoint, there's a lot of paperwork once you're injured, be it a car accident or a workers' comp case, a labor law case. And a lot of times people say, you know what, let me write it, I'll handwrite it, I'll submit it. It's very, very important to contact the attorney or someone that has knowledge, because how you fill out those applications can greatly affect what goes on in the case, whether even your benefits are paid. For example, in a no-fault application for a car accident, if there's it's a 3-page application, and one of the questions is, were you working at the time? A lot of people say, well, yeah, I was on my way to work, and they check yes. Well, now it's no longer now it's a workers' comp case, which has different ramifications on your car accident, on getting money back for lost wages, when in actuality, you were on your way to work and it wasn't due to, what's not a workers' comp case, for example. Rich, on other applications with labor law cases and unemployment and disability, all that can be greatly affected. Sure. And those applications are so very important. And I find, and Rich and I were talking about this past week on a few cases that came in, that some other attorneys will tell you, you know what, just fill out the paperwork, you can get a lot of paperwork, and then just give us copies. Now that to me is a lazy attorney, and you hire an attorney to do work for you.
You know, Brett, we're going to get into that in a few minutes. Right now, we're going to cut the commercial, and when we come back, we're going to talk about, what your job is to do as the client and what the attorney's job or the law firm's job. And then we're going to get into something which seems to happen a lot, is a slip and fall. And is the place where you fell ultimately responsible? Do they have a period of time to be notified, et cetera, et cetera? But we're going to cut the commercial. You're watching Legal Straight Talk right here on Madhouse TV with the Harrison Law Group. We'll be right back after this.
Welcome to Formula Auto Wash, where every day is a great day for a car wash. Open 7 days a week from 8 a.m. till 5:30 p.m. Sundays 8 a.m. till 4 p.m. Detailing packages for every budget, starting out at $29.99. 100% hand wash and detail centre. Hogshair and microfiber brushes and mitts. Proudly using Ecolab Blue Coral soaps and waxes. Formula Auto Wash has served the community for over 30 years. Senior discounts all day, every day. Ladies' Day Wednesday, $3 off any wash. Early bird discount Monday through Thursday till 9:30 a.m. Check out our website, formulaautowash.com.
Hi, this is Mickey B. Join me for my Saturday Night Disco Fever Dance Party Volume 2, Saturday, October 6, 8 p.m. at the Memorare Ballroom, 2183A Jackson Avenue, Seaford. Starring live Alicia, Barbara Roy, former lead singer of Ecstasy, Passion and Pain, the Trickshot Disco Orchestra, and DJ Ace playing all your favorite hits of the 70s. 5-hour disco party, full hot buffet, cash bar. For tickets and information, call 516-822-9612, 516-822-9612, or MickeyB.com. Sponsored by...
I was nervous about selecting the perfect paving stones for our project.
There are so many choices, I didn't want to make a mistake.
After all, it is our home.
It had to be the most beautiful patio.
An exquisite driveway.
A stunning backyard oasis.
I chose Astro for the largest selection.
The best prices.
The magnificent displays.
The finest service and expert advice.
I chose
Astro.
Astro Masonry and Supply. Call 631-242-2567 or go to astromasonry.com.
Okay, welcome back to Legal Straight Talk. I'm Tom Mealy. I'm here with the Harrison Law Group and Rich Coleman and Brett Harrison. One more time, again, our phone number at the Law Group is 516-390-0808. You can call in right now if you have any questions regarding any of these topics. And again, if you're listening somewhere out of the state of New York, throughout the United States, and you have the need for a lawyer, if you have any questions, it doesn't cost to make the phone call, especially if you have Verizon or Sprint, because you know how the cell phones work. But anyway, that's another point. But the issue is that if you have questions, don't dwell over it. Give us a call. Let us help you out. There's no price and no cost for free advice. Anyway, let's get back to paperwork. When you hire a lawyer, it is his job to do that paperwork. If he tells you, no, you go do the paperwork and then come back, or go to the doctor and then come back if you have an injury, do me a favor, run as far away from this person as possible. All right, to me, and I'm sure to our host, that's a lazy lawyer. Rich, tell us, or Brett, how imperative is it to make sure that the documents that are submitted to that insurance company at the start of any case, whether it's a labor law case or a simple slip and fall, tell me how important that is.
Well, it is critical, simply because in any particular case, whether it be a car accident, labor law, slip and fall, whatever type of case we're handling for the client, if the client makes a statement or fills out puts a check next to a box and then puts their signature, that document could be a potential landmine later on in the case. What do I mean by that? Perhaps the client who is not very good at writing puts something in the description of the accident that really isn't accurate. They're just trying to get it down, but they're really spending a lot of time and focusing in on it. What will happen later is if that case goes to trial, the lawyer for the defense, for the insurance company, can then cross-examine the client to try to show that the client earlier, close in time to the accident, made a contrary statement, and that could be devastating.
Let me just stop you for 1 second, because one thing that I find very important when filling out, especially a no-fault application, is on that application, folks, it says describe your injuries. You're not a doctor. You don't know what your injuries are. You know where they are. You know that it may be your neck or your foot or your back or your this, but it says describe your injuries. And Rich, that can come back to haunt you. When we fill out, or when a law firm, a respectable law firm, fills out that document and doesn't depend on you to do it, we put in that space to be determined or submitted by a medical narrative or medical personnel. There is no way, and I don't know if I'm right with this, Rich, but that's a very critical part of that no-fault application, is it not?
That's correct, as well as any other document that requires you to list and describe your injuries. Clearly, we're not physicians, and we're not writing medical reports on these applications. But what we try to do is highlight, based upon what the client advises us and any medicals that they do bring in, that there are specific type of injuries that occurred during the accident. And therefore, if we leave that, if the client leaves that out, again, that is something that can be utilized against the client later on in the case, saying, well, you knew you had a neck sprain, and all of a sudden, 5 years later, you're claiming that in the case, or 3 years later, when you just had the neck sprain but omitted it. So
you're saying omitted it from the no-fault application?
Yes. In other words, when the client fills out the no-fault application and lists the injuries, intending to do the right thing, but not being attorneys and understanding the ramifications of leaving things out or omitting them, could be harmful later on.
Well, wait a minute. See, now that's just the opposite of the way I'm thinking. If they put in that no-fault application that they have a neck injury, or they have a leg injury or a back injury, isn't that disclosing information that normally we wouldn't want to do? If they went to the hospital, and in the hospital room or in the emergency room they said to the doctor there, yes, my neck, my back, my foot, my leg, my shoulders, whatever the case may be, now we're documented. If we put in that no-fault application and start to describe injuries, there's a secondary issue of what's called an independent medical exam. Now, you got to remember, that insurance company, your carrier, is now getting that documentation. They can, based on what they see on that no-fault application, order an independent medical exam, which we'll get into in a second, and how critical that is. But would it not be in their best interest to just put in that description of injury to be determined, as long as, A, they discussed it in detail at the time of the emergency room and we know that it's in there?
What's happening today is, just quickly on this, is that if you are too general in the area of description of injuries, it's saying to be determined, the no-fault insurance company, through their adjuster, may defer payment of medical bills until there is a little bit better description. What I think is good and better practice is to list the general injuries and also indicate, because there may be other injuries that evolve from that or yet to be determined after going for medical care and treatment, if that be the case, that there are other serious and severe injuries, full extent unknown.
Right. Well, and in essence, a lot of times when I'm reviewing some of the applications and after discussing it with the client, often we'll put multiple injuries to the entire body, full extent not yet known, injuries including but not limited to. That kind of leaves it open a little bit. And another reason why you want to leave it open is a lot of times after conversations with many of the doctors that I've had, they tell me a lot of times it takes 3, 4, 5, or 6 months to know the full extent and whether it's permanent or not. And, you know, a lot of times people, when they're injured, if they broke their leg, they're only focusing on their leg, not realizing that a lot of the pain they're having is also in their back, in their neck, and so forth.
And again, this just recaps on why it is imperative that when you're involved in an accident, don't take it upon yourself. Don't fill out paperwork. Don't say anything. Don't give statements, because everything that you do, every small thing that you do that you may think is the right move, may ultimately come back to bite you.
And in addition, Tom, you know, a lot of times what sometimes the client will write and submit on their own may in and of itself cause the case to go to trial because they now created an issue, be it medically or on a liability standpoint, that they didn't intend.
Yeah, it is important. You know, one thing you got to remember about personal injury, which is great for the client, and this is the way I explain it to clients when I see them. You know, I tell them, listen, it is a contingency. In most cases, it's a contingency. You know, that you have the protection, you're comfortably under the umbrella of a very seasoned law firm. And, you know, at the end of the day, let's assume that you don't have anything. At least you know that everything along that path was done correctly, and you will not be responsible, be it a medical bill or a property damage bill. You're covered under that umbrella. So really, I mean, at this point, what do you have to lose? You hire a law firm who gets a flat fee only if they win, and if they lose, all that work they did, you're getting the benefits of making sure that all your ducks are in a row, and it's done under their umbrella, and they're the experts. They're the ones that know what's going on. Let's get into a slip and fall, because slip and falls are a little bit different than automobile accidents. Rich, when you have a slip and fall, let's take a simple slip and fall in a supermarket. People don't understand what notice is, what notice isn't. If Johnny is with his mother and he's in the mayonnaise aisle and he knocks that jar of mayonnaise off the shelf and it falls on the floor, and all of a sudden Susie Jones comes riding by with her carriage and she slips on the mayonnaise 2 minutes later, is the supermarket responsible for her injuries?
Okay. Slip and fall cases are a more difficult type of case for lawyers that handle personal injury cases for clients. And what you highlighted, Tom, is the issue that always is the problematic area in these cases. What is that? It's called notice. And what is notice? In your example, the mayonnaise jar was knocked over. 2 minutes later, another patron comes by and unfortunately slips and falls on some of the mayonnaise that's lying on the floor. The question that the client has is that comes in that fell is, do I have a case against the supermarket? And very fact-based, issue-based determination. Under the law in New York State is that in order to hold a property owner or the owner of the supermarket legally responsible for causing your accident, you have to show that that supermarket or owner of the property had reasonable notice prior to your accident to have taken action, remediation, to have known that the condition was there, and then taken action to remove it, clean it, make it better. In a supermarket context, and I've handled many of these cases, a lot of times the supermarket's position is, how do we know? I mean, this just happened. We only have to act reasonably. And what that means is, if there was 2 minutes between the time the mayonnaise jar fell and the time the client came and slipped and fell, is that a reasonable period of time for the supermarket to have taken action, to have known about it and cleaned it up? Well, that depends on a couple of things. What's the practice and procedure that the supermarket has with their cleaning crew? Do they come around regularly? Are they supposed to come up and down the aisles on any sort of set schedule? And what is that set schedule? Is it written in stone? Are there logs? Are there manuals? A lot of times the supermarket says, well, look, 2 minutes is not a reasonable period of time. These cases are difficult cases. They're not impossible. We do take them. But a lot of times we have these difficult issues to contend with.
No.
Okay, Brett, here's a question for you. The other day I got a phone call from a woman. In fact, it was last night, and I know that we touched briefly on this when I had called you. The woman's in the supermarket. She's at the cash register. She slips and falls on water. The unique thing about this is that the water that she fell on was coming out of a box from a display that the supermarket placed at the end of the checkout or right before you get into the checkout, and in that display was a bucket of water and it had flowers in there, live flowers. Now, in that particular case, they created a condition. Explain to us, Brett, the difference between that and the mayonnaise jar.
Well, one is you're just stacking, and maybe the mayonnaise fell because some other person knocked it down, or it just fell, and how long it was sitting there. There, it's an issue of notice. Here, with the flowers, they positioned the flowers there. They possibly created the condition, and that's a big difference because they are aware that people are going to come to the register. They're inviting people to come to that part of the register. They have it open, knowing people are going to be there, and knowing that they put the flowers there. Should they have been aware that it could leak and that there's water in the flowers that could be knocked over? That's where the issue comes in.
So at that particular point, now they don't have to have notice of the leaky water because they created the condition and should have realized or checked that periodically. So now the issue, Rich, of having noticed that there is water on the floor is a moot issue at this point.
Yeah, if you can prove as a lawyer for your client that the party, the defendant, the owner of the property, actually created the condition themselves actively, as opposed to some third party being involved, and then you have to deal with the difficult issue of notice, your case is enhanced by multiple times. To give another example is if you're walking down the sidewalk and there's an uplifted sidewalk from tree roots, depending upon the municipality on the island where we live, and there are different ordinances that apply to maintenance of the sidewalk for the homeowner, and you trip and fall, as opposed to that homeowner is actively doing construction work on the sidewalk, and didn't put tape around it or left it broken up. Two different, the result is the same. You trip and fall, you get hurt, you break a leg, you break a wrist. But from a lawyer's point of view, it is much easier to prove that the homeowner created the condition rather than they had notice of the uplifted sidewalk.
So the homeowner created, well, let's take a sidewalk with a tree. Let's say that the tree actually created the sidewalk to lift. The homeowner living there has noticed that that condition is there and creates a hazard, correct?
Yes, but there is a further complication. In Long Island, where we live, the law has evolved on sidewalk cases, uplifted sidewalks caused by tree roots, to the point where essentially if you are injured on an uplifted sidewalk from tree roots, using your example, the location, as we say in the real estate business too, is what determines whether you do or you don't have a case. What do I mean by that? Different municipalities have passed ordinances that require the homeowners, the abutting landowner next to the sidewalk, to maintain the sidewalk. And if they don't, they could be fined by the municipality who comes and fixes it for not taking care of the sidewalk. But that in and of itself doesn't create legal responsibility on the homeowner. Why? In New York State, our highest court, which is the Court of Appeals, has previously determined that unless this specific ordinance, for example, the town of Oyster Bay has an ordinance about sidewalk maintenance, and it specifically says in it that if the homeowner doesn't maintain the sidewalk and creates a dangerous condition, and someone is hurt and has injury or damage, then that homeowner is responsible. And
Okay.
the key to that is, Tom, is that the language in that ordinance of that municipality, for example, the town of Oyster Bay, that says that the homeowner will be responsible for any personal injury, as opposed to the homeowner just will be fined for not taking care of the sidewalk.
So again,
Makes or breaks the case.
We have to again just recap that, understand that this is what makes a law firm good. Listen, we're going to cut the commercial, and when we come back, we're going to talk about another aspect of slipping and falling in something called open and obvious, which could actually change the whole dimension of your case. So you're watching Legal Straight Talk. I'm Tom Mealy with your hosts, Brett Harrison and Richard Coleman from the Harrison Law Group, located right here in Massapequa, New York. We'll be right back after this message.
Hey, it's JP for the Harrison Law Group. A few months ago, actually, I had a family member that had a little bit of an accident. No broken bones, but there was a lot of pain involved. She was like, I don't know what to do. I don't know what to do. And I remembered hearing the guy, Tom Mealy from the Harrison Law Group, always yelling about a lot of law firms always say, if it's not broke, then you don't have a case. And I said, you know what? Why don't you give Tom a call for yourself? 1-800-INJURY-LAW. She got Tom on the phone, and when all was said and done, she ended up getting a nice chunk of change. So if you or a family member have had any sort of injury, you have absolutely nothing to lose by dialing 1-800-INJURY-LAW and talk to Tom yourself. Look, you have no idea what the laws are. Let Tom, Brett Harrison, and the pros at the Harrison Law Group take care of you. Again, the number is 1-800-INJURY-LAW. Just because it isn't broke doesn't mean you don't have a case. My family is living proof of that. So if you've had any sort of injury, any sort of accident, the first and only call that you need to make is to the Harrison Law Group, 1-800-INJURY-LAW. That's 1-800-INJURY-LAW. Now, what are you waiting for? Call them today.
What is Grand Prix Motorsports? It's a full-service motorsport performance and service shop. It's West Coast custom style, East Coast pricing, old-school customer service, custom-built bikes, all-out performance upgrades, and free towing too. Grand Prix Motorsports is automobile, motorcycle, jet ski, and ATV, performance, service, and repair. It's online at GrandPrixMS.com. Grand Prix Motorsports, Long Island Avenue, Deer Park.
Welcome back to Legal Straight Talk. This is Tom Mealy. You're here with the Harrison Law Group and Brett Harrison, Rich Coleman. You know, before we left, we went to commercial. We were talking about open and obvious. But before we get to that, Brett, you wanted to just touch on one more quick issue on what we were talking about. What is that?
And that's with the supermarket cases. When you have a slip and fall in the supermarket case, it's very important at that point to, when you, oftentimes a manager will come and take a report down. What you should do is make sure you get the manager's name and full title, and also ask them, can I have a copy of what I'm just signing? Also review. Often the manager writes down and the report and says, just sign here. Make sure you review that report. Make sure it's accurate. Ask where can I get a copy of it? What office is it going to go to? Now, in addition to that, it's also important if you're on the ground, look at what you slipped on. For example, was the water dirty? Was it clean? Was there orange juice? Was there grease? Try to get an idea. And nowadays, everybody has a camera phone. If you can, take a picture. And also note the aisle where it happened. And lastly, I would say is it's also important to go to an attorney rather quickly, because often, and in most supermarkets, they have cameras. And you need to contact them and put them on notice to preserve any videotape.
Very good. All right. Listen, this is not a ticket. People make mistakes. Supermarkets make mistakes. And understand something, that if you're hurt and there is a clear issue of liability, then yes, you call a lawyer because you are entitled to certain extras. But let's face it. If you're walking down there and you slip and you just bruise your behind, you know, people make mistakes. They don't deliberately set these things out to hurt you. So, you know, please don't make a mountain out of a molehill and try, you know, to burden the courts with frivolous lawsuits and frivolous claims. If you've gotten hurt as a result of clear negligence where that individual deliberately ignored a situation which could have caused you bodily harm, yes, then you have a case. Let's stop, you know, filling these courts with all of these BS type lawsuits that really don't matter, thinking that, you know, it's a lottery ticket. It's not a lottery ticket. You're entitled to compensate if somebody clearly, you know, had a problem and didn't fix it, and you got hurt as a result of it. Rich, real quick before we wrap up for today, open and obvious. Open and obvious is another issue which could take percentages away from the type of case it is and what you may be entitled to.
Yeah, the open and obvious is the term that's used usually by the insurance company adjuster or the lawyer for the defense for the insurance company. It basically is the concept that there was, if you tripped and fell or slipped and fell on some sort of a condition, the claim is that it was open and it was obvious and you should have seen it. And therefore, any entitlement to damages and award of monetary damages is reduced accordingly by your percentage at fault, your comparative fault for not seeing this open and obvious condition. Right. That is a problematic area in the slip and fall cases. We have to contend with it. But the courts have also carved out, as they always do, certain exceptions to every rule. And the exception there is even though there may have been an open and obvious condition, that does not mean that the property owner or the owner of the area where you fell did not have a duty, a legal duty and responsibility to maintain the area. It doesn't mean that they can create a condition, meaning the property owner, that is a very bad and defective condition, an open hole, for example, where work is being done, leave it, you fall in it or you trip in it, and they have no responsibility. No, that's not what open and obvious means. Open and obvious means that it's a condition that reasonable people should have seen and should have avoided, but that doesn't mean that the landowner or the property owner didn't have a legal obligation to make sure and maintain that area, such as putting yellow tape around it, sawhorses, or whatever.
Right. Okay, we're going to wrap up now. You've been watching Legal Straight Talk. Next week, we have a little bit of a treat. Next week, we are fortunate enough to have Dr. Gramsey. He has an office in Amityville, New York. He will be here live. We're going to talk about medical issues. What is soft tissue? What is not soft tissue? We're going to get into what could happen in any type of an accident, whether it's a car accident, a slip and fall, or workers' compensation type accident. So, again, thanks for watching Legal Straight Talk with the Harrison Law Group, and we will see you next week with Dr. Gramsey live here on the Madhouse Studios. Thanks for watching. Have a wonderful week.